Hello, everybody. This is Farhan Mirza, and I'm working as the Vice President and Global Head of Global Sourcing and Supply Chain Management at Wind Limited, which is a wind turbine manufacturing company out of Helsinki, Finland, for the past 3+ years. Prior to that, I was the Global Director of Supply Development, Value Improvement, and Warranty Management at Clipper Wind Power out of Santa Barbara, California, and for about 3 years there. And prior to that, 10 years with General Motors, various roles within manufacturing, quality, and supply chain management. And the most recent role before I left General Motors was global quality and purchasing manager for new vehicle launches. And coming into today's topic, we'll be discussing primarily contract management, and where it starts is basically we what is the broad topics to cover would be some definitions of contract negotiations and how they pertain to supply chain management, objectives of a negotiation. Third would be best and worst cases of negotiations. The fourth subtopic would be negotiations tips. The fifth topic would be contract drafting tips. Sixth would be strategies for planning contract negotiations. Seventh subtopic, evaluations of negotiation outputs. And eighth would be what can go wrong. And ninth, as a summary, would be what determines a win-win outcome. So going into negotiations, process of bargaining that precedes an agreement. Successful negotiation generally results in a contract between the parties. That's the Barron's Business Dictionary definition. And there are a couple of quotes which I always remember, that when a man says that he approves something in principle, it means he hasn't the slightest intention of putting it in practice. That's by Otto von Bismarck. And grant graciously what you cannot refuse safely, and conciliate those you cannot conquer. That's by Charles Caleb Colton. So these are the two things which, as quotes, which come usually to my mind in negotiations. And there are a couple of proverbs I would like to state here. Buying is cheaper than asking. It's an old German proverb. And there's a saying, the authors are known. It goes as you must be fully prepared to lose a great deal in order to make a great deal, which in my mind comes to more of win-win. The goal is not to kill someone to gain something. It should be what someone else can gain across the table and what you can gain on your side of the table, and make it a long-term relationship. And as William Shakespeare had said, we were not born to sue, but to command. Moving into negotiation objectives. Number one is certainty. The aim of the contract negotiation is firstly to achieve certainty, to record what is being supplied, when, in what quantities, and to what standard, and what are the consequences of delay or failure to meet the agreed requirements. The next thing would be, as an objective, the best deal. Seeking clarity does not conflict with the view that negotiation should be achieved the best deal. It merely points out that both parties to a negotiation have to understand what is it that they have agreed to. Again, that should be the best deal. Third objective would be achievement of organizational goals and objectives on both sides. Fourth would be creation of a long-term relationship between the two parties, which are coming to an agreement of signing the contract. The broad attributes to pre-contract negotiations, our next topic or subheading. Scope management, quality management, time management, cost management, risk management, and customer satisfaction. These are the 6 pillars which are required to be honed in for pre-contract negotiations. Then we come into strategies for planning contract negotiations. Firstly, rank your priorities along with alternatives. Second, know the difference between what you need and what you want. Third, know your bottom line so you know when to walk away. Fourth, define any time constraints and benchmarks. Fifth, assess potential liabilities and risks. Sixth, confidentiality, non-compete, dispute resolution, changes in requirements, all have to be documented ahead of time and agreed on. Seventh, do not use the same talk. You have to walk a mile in your vendor's shoes or your customer's shoes. Do the same for your vendor or customer what you are stating. Just don't do lip service. You have to mean what you say, what goes in a contract with the intention of going in a contract. And that's how risk versus the cost and the impact has to be judged. Non-disclosure agreement, I have to emphasize here, before launching any negotiations, documents or exchanging any data, you have to have a non-disclosure agreement in place. This avoids all sorts of complications as you move forward. Preparations for negotiations, the next subtopic. Select the shortlisted suppliers for contract negotiation. You cannot go about trying to deal across the board with all suppliers at one go, or just trying to play the field and see what works out best. You have to have a good idea with whom you want to do a negotiation and what the time is worth, what the effort is worth, and whether that component, commodity, or customer or supplier is really capable of handling the negotiation, and is it worth the time and effort. Secondly, establish cross-function negotiation teams for the negotiation. Just don't go walk in or say casually you're walking in to someone's facility or invite someone over. Make sure you have the right team which is sitting with you and across the table to make the process go smoother and conserve time to the maximum possible and make it an effective process. Third, actual contract negotiations. Each issue of negotiation should be resolved individually. Don't club things together. Unanswered issues should be noted and discussed in a follow-up discussion or after a break in the same discussion. Summaries should be made of resolved issues, so you have a checklist of what's resolved, what's unresolved. And don't give hope that a particular supplier or customer may be entering into a contract when you still have open issues on the table. Make sure you resolve things before you commit to the final goal. Preparations for negotiations. One more aspect to remember would be determine if you would need legal counsel and make sure you have them by your side, and the other party also knows you're going to have some legal counsel because of the issues. So then it's clear and you're not hesitating to involve legal at the last minute. The next point within the preparation of negotiation is make sure you identify ahead of time. Is it going to be on-site or it's going to be teleconference? I generally prefer face-to-face negotiations on-site, looking at someone right across the table and then doing the discussions. The next point within the preparation for negotiation would be make sure that persons representing the vendors or the customer have the authority to negotiate on behalf of their organization. Negotiation tips as a next topic. Always have clear objectives. It helps to make a list of goals before meeting the other party. Secondly, it is important to go to a negotiation having done your research. Know the relevant laws, facts, and figures. Third, consider what you really need to get from the other party and also decide in what areas you're willing to compromise. Fourth, build trust with the other party. Trust will aid in communications. Fifth, it is always better to have a first draft of the agreement written before meeting the other party. Sixth, try to keep the discussions ordered when meeting with the other party. Make the checklist of topics that you would like to cover and then make sure you check off that list as you progress. Listen to the other party and their concerns. Don't always be the only person doing the talking. Things to consider. Do you know the other party? Have you done business with them? Secondly, consider doing a credit check if you haven't dealt with the party before. Third, if the other party is based abroad, make sure you take legal advice to ensure you have a proper protected local laws, your product, liabilities. It's all covered if things go wrong. Fourth, are you happy to allow the other party to subcontract some or all of the work or pass on the benefits of the contract to others? If not, this must be made clear in the contract. Fifth, is it a fixed price contract? If not, then incorporate clear price variation formulae linked with published market indices for the key components or materials which go in the product. Are goods delivered, delivery cost included in the price or not? So these are the 6 things which you need to consider while framing the contract. The main rule of contracting policy is always, whether long-term contracts, short-term contracts, they are all leading to a relationship. Agree in writing. The only proof of what has been agreed is the document signed by both parties. Contract drafting tips as a next subtopic. An effective contract should always be clear, specific, and focused. Secondly, sentences should be short to avoid unnecessary complexity and ambiguity. Third, have a look at some sample agreements prior to drafting your own. Fourth, make sure all party names are accurate, include their business titles if applicable. Fifth, make a contract where it's consistent in its tone, grammar, word usage, and abbreviations. Well, sixth, outlining the contract can aid clarity and allow for quick reference to certain clauses. Seventh, define the important terms. Eighth, anticipate litigation by including sections regarding venue and choice of law. Ninth, all parties should sign the contract, including the business titles where applicable. Number 10, pages should be numbered. Avoid appearance that pages could have been added after the agreement was signed. 11th, as with any business writing, proofread very carefully. Legal views. Involve your solicitor at an early stage so they can fully understand the commercial context and aims. Let your solicitor help with strategic planning. Let your solicitor provide guidance on any relevant rules and regulations at the negotiation stage. Remember that early involvement is much more effective than a last-minute review once negotiations are mostly complete, as this avoids having to change a pre-agreed position. Post-negotiation tips as a next topic. Kick off the meeting. Define roles and responsibilities and communication channels. Secondly, appoint a project management team or an external company to monitor and manage the contract. Number 3, periodic coordination meetings. Number 4, periodic progress reports. 5th, cost monitoring and financial management. Every quarter, every 6 months, whatever has been agreed, you got to follow. 6th, quality inspection. 7th, claims management. Whether it's warranty or liabilities, they have to be reviewed and managed at least quarterly is my suggestion. And 8th is contract closure. Evaluation of the negotiations output. In every purchasing or supply chain contract, you have to evaluate output. This is even so more important because the entire organization is looking at this supply chain function to see how many contracts were negotiated, how many were closed, how many were open, and what reasons were open, and what liabilities and risks are hanging out there for the organization. That's why evaluation of negotiation output as a next subtopic, I would give 5 pointers. 1. What could go wrong with the deal and what loss could you suffer as a result? Consider all possible consequences. If buying, trying to ensure that the seller is responsible for all possible losses, including consequential losses, and that liability is not limited in any way. If selling, try to limit liability to a fixed amount. Resist any responsibility to consequential losses, as they may be far greater than the contract amount and impossible to quantify. 4th, a clear timetable is essential, especially if price is tied to delivery or performance dates. 5th, do you know or do you want to be able to end the contract or to impose a financial penalty if work or goods are delivered late or not delivered for reasons beyond an act of God? And what can go wrong as a next topic? Poor planning, failing to pay attention to your party in front of you, assuming that cross-cultural negotiations are just like local negotiations. This is a big no-no. They never are. Cross-cultural sensitivities and the implications of how things can go wrong, all have to be considered. Paying too much attention to anchors, caving in too quickly, and do not gloat. And then one important thing would be all of this as a culmination, I say, has to be supplier appraisals. Why are supplier appraisals so important before going into contract negotiations? Issues and problems can be identified and resolved quickly. They signal to the organization whether taking a supplier for negotiation is really worth it based on the supplier's performance. The supplier appraisals help align suppliers with organizational goals. Good suppliers will be more willing to work with you. Poor performing suppliers will be rooted out quickly when you do the evaluations or supplier assessments. Effective risk management. Cost savings because supplier appraisals will tell you where the bang for the buck is. Effective relationship management, effective management of preferred supplier lists, and it promotes continuous improvements. And last but not the least, in my opinion, supplier assessments highlight possible weaknesses in the system. And best and worst case scenarios as my next subtopic, and which is the summary of my discussion here. Number one, the worst contract negotiation is to bleed every last cent out of the vendor for the lowest price. Secondly, remember, you want to partner with your vendor so that both you and your vendor or your customer will meet your corporate goals and objectives by signing the contract. And lastly, a signed contract that benefits both parties will provide a firm foundation to build a long-lasting relationship with your supplier or your customer. That brings us to the end of the session. Hope all of you enjoyed it, and any questions, comments, feel open to ask in the blog or email me. Thank you very much.